This is Deborah Brake, Professor of Law at the University of Pittsburgh School of Law, and I'm going to talk about the Supreme Court's recent case in Young versus UPS, which it decided March 25th, 2015, and what it means for pregnant workers and these kinds of claims going forward. So pregnancy has always been a tough sell for the law in trying to figure out what equality means in a situation of real difference. In the 1970s, the Supreme Court struggled mightily with this issue with some rather poor effects. So the Supreme Court's first take on pregnancy discrimination was in 1974 in the now infamous case of Geduldig versus IAO, where the court surprisingly ruled that discrimination on the basis of pregnancy was not sex discrimination at all, but discrimination between pregnant persons and non-pregnant persons. Of course, lost on the court that pregnancy discrimination necessarily hurt women. 2 years later, the court replicated the error in Title VII in finding that in Gilbert versus General Electric, a policy that provided temporary disability coverage and leave for accidents and injuries, but not pregnancy, once again was not a form of discrimination on the basis of sex. 2 years later, in 1978, Congress responded to this state of affairs for Title VII by amending the statute with the Pregnancy Discrimination Act. There are two clauses to the PDA. The first one definitionally states that discrimination because of or on the basis of sex includes discrimination because of or on the basis of pregnancy and related medical conditions. But there's more to the PDA. The second clause provides that persons affected by pregnancy or childbirth or related medical conditions shall be treated the same as other persons not so affected, but similar in their ability or inability to work. And it's this clause that's at the heart of the court's recent case in Young versus UPS. So for many years, the state of the law was somewhat in flux about what pregnancy discrimination meant. Interestingly enough, the Supreme Court's very first case of pregnancy discrimination involved, if you can imagine it, pregnancy discrimination against men. The claim there was that the employer's policy provided health benefits for all kinds of conditions for employees, but limited coverage of pregnancy for the spouses of employees, which meant that female employees had full coverage for pregnancy, but the female spouses of male employees did not. The court had no trouble, incidentally, seeing that as a form of pregnancy discrimination in violation of the statute. And then there were a couple of other less esoteric cases involving pregnancy discrimination where the court applied the statute quite clearly and found, for example, that fetal protection policies excluding women from the workplace and from particular jobs were a form of discrimination against potentially pregnant women in violation of the statute. So the law chugged along for a while until an interesting thing started happening 10 or so years ago in the lower courts, where claims started cropping up where women challenged policies of accommodating some workers with non-pregnancy conditions, but not pregnant workers. The cases included things like on-the-job injury policies, where employers gave accommodations to workers with on-the-job injuries, but not pregnancy. And gradually, the kinds of things that employers gave accommodations for begin to expand beyond on-the-job injuries to include things like disabilities, of course, which employers are required to do under the ADA, and even other kinds of accommodations while still ruling out pregnancy. So Young versus UPS involves this kind of a fact pattern. Peggy Young was a driver, an air driver of light packages for UPS when she became pregnant and was put under a restriction by her doctor of not lifting more than 20 pounds on the job, partly because of a previous record of miscarriage. And that seemed perfectly fine because her job didn't really require lifting anything higher than 20 pounds. On the very few occasions where there was that kind of lifting to be done, she was always able to get a coworker to help out. But when she brought that doctor's restriction note to her employer, Surprisingly, the employer told her that she couldn't stay on the job, that the job description required lifting 70 pounds or more, and even though she didn't do that on a day-to-day basis, under the employer's policy, she wasn't allowed to stay on the job. Well, that seemed all the more unfair because looking at the UPS policy in terms of what was given light-duty accommodations, almost everything else was. On-the-job injuries, certainly, but also any kind of condition that amounted to a disability under the Americans with Disabilities Act, and even for any reason, an employee losing their Department of Transportation certification to be a driver was able to get inside work, which could include light-duty assignment. So it really stood out that pregnant workers were not able to get this kind of accommodation. So in Peggy Young's case, she not only lost her job, she lost the health insurance that went along with it. So the Fourth Circuit, in leading up to the Supreme Court's case, made a ruling that was similar to a number of lower court rulings that had been going on, which is to say that, well, for all of these other workers getting an accommodation, there are pregnancy-neutral reasons for doing so. So for the disabled workers, well, the ADA requires the employer to give them an accommodation. Or the on-the-job injury folks, well, the employer is giving them an accommodation in order to keep the workers' comp premiums low. Or the people who lose the certification to drive, there's a legal reason why they can't continue in their existing jobs. And you can see with that kind of reasoning, you could explain away any different treatment of pregnancy, since there's always going to be some kind of a plausibly neutral sounding explanation for not folding in pregnancy. And in fact, the policy in Gilbert versus GE could be explained in those terms as well, that it's accommodating accidents and illness in a pregnancy-neutral way. It's just that pregnancy doesn't happen to be one of those things. So the Supreme Court took the case and in a very recent ruling on March 25th decided that the lower court had used the wrong kind of reasoning in rejecting this kind of claim. And going forward, Peggy Young should have the opportunity to show that other workers who were not pregnant were getting accommodations that were denied to her, at which point the employer would be able to try to show a legitimate non-discriminatory reason to explain the different treatment. But the court cautioned that not everything counts as a legitimate non-discriminatory reason. For example, the fact that it would cost more to cover pregnancy and accommodate pregnancy isn't really a non-discriminatory reason to defend such a policy, since even the General Electric policy could be explained in those terms. The fact that pregnancy might cost something more to treat it like other conditions isn't a reason under the PDA for treating it differently. And then finally, the Supreme Court ruled that once the employer shows a justification for treating pregnancy differently, the employee still needs to have the opportunity to show pretext. And this can be done by showing that the employer's justification is not strong enough to explain or defend the significant burden that the policy puts on pregnant workers. I think this is a good ruling for pregnant workers and very much attuned to the kind of problem that the Pregnancy Discrimination Act was designed to get at. Pregnancy discrimination has never been about animus towards pregnancy or a dislike of pregnant women. Rather, it's really been about the devaluing of pregnant workers based on stereotyped assumptions that pregnancy foretells the beginning of maternity, which means detachment from the workplace, less reliable and less valuable workers. And so the history of pregnancy discrimination was very much a history of employers not making the investment in pregnant workers, not out of animus, more out of indifference or predictions about the values of those workers. And the framework that the Supreme Court has come up with, I think, is a framework that will do a good job at sorting out just that kind of stereotyping by really probing the employer's reason for not investing in pregnant workers. It should flesh out exactly the kind of stereotyping and devaluation that the Act was designed to get at. So I think it's an important ruling, and I think it's an especially important ruling for the women most vulnerable to this kind of discrimination, and that is largely women in low-wage jobs, in inflexible workplaces, where women, when they become pregnant, do need small kinds of accommodations, sometimes relatively costless accommodations, things like carrying a water bottle, restroom breaks, sitting instead of standing, and where those kinds of accommodations are made for other classes of workers. It opens the door to courts carefully looking at employers' justifications for not giving them to pregnant women. The other kind of class of cases where this will likely do a good bit to help pregnant workers is in non-traditional work. Work such as firefighting, police officer jobs, construction jobs, work that does require some physical exertion. And in many of those jobs, for a long time, those employers have given light-duty accommodations to broad classes of workers, and yet not pregnant workers. So the court's ruling should help open the doors to women in non-traditional jobs, as well as women in the more structured, rigid workforces, so that women don't have to trade their paycheck for their pregnancy.